The amendment.
Amendment number 1, printed in House Report number 110-422, offered by Mr. George Miller of California.
Pursuant to House Resolution 793, the gentleman from California, Mr. Miller, and a member opposed will each control 10 minutes. The gentleman from California is recognized.
Madam Speaker, I yield myself 4 minutes.
The gentleman is recognized for 4 minutes.
Madam Speaker, I rise in support of an amendment to this end of legislation that I and Mr. Stupak have written to ensure this law will protect religious liberties of religious corporations, societies, associations, and in particular, religious schools, including those religious schools that are not affiliated with any particular church or denomination. Our amendment would make it clear that the end exemption matches the religious exemption found in Title VII of the Civil Rights Act of 1964. Under my amendment, the religious corporation, association, or school would be categorically exempt from ENDA. In addition to our amendment, it also clarifies that the references to the term married refer to the federal definition of marriage as between one man and one woman as enacted in 1996, federal law referred to as the Defense of Marriage Act. With respect to the religious exemption, this issue has been a cause of a lot of confusion in past weeks. The religious exemption that was part of the ENDA bill that was passed out of the Education and Labor Committee on October 18th was exceptionally broad. However, several non-denominational religious schools nevertheless raised concerns that they might not be covered under the ENDA exemption. For example, the president of Wheaton College in Naperville, Illinois, sent a letter to Representative Tim Walberg in advance of the Education and Labor Committee's markup on ENDA. Mr. Walberg shared that letter with the entire committee, and our Republican colleagues argued that Wheaton College, which is clearly a religious school, despite the fact that it is not controlled by any affiliation or with a specific church or covered by the ENDA, may not be covered by the ENDA exemption. That argument was incorrect. Wheaton, along with other religious schools and organizations such as the Council for Christian Colleges and Universities, asked that we ensure that the Act categorically exempt religious organizations as in Section 702A of Title VII, and we have done precisely what Wheaton College and the Council for Christian Colleges has asked us to do. Under this amendment, if a religious organization, including a religious school, is exempt under 702A, the broader section of 703E2, then the organization or school is exempt from ENDA, period. If a school qualifies in either one of those exemptions under Title VII, it is categorically, as they requested, exempt from ENDA. By directly referencing Title VII, we also ensure that many decades of case law on Title VII religious exemption are imported to ENDA. This amendment provides clarity for religious schools that have experience with the Title VII exemption, and it should satisfy all of the legitimate concerns about ENDA. Let me be clear. The Title VII exemption, and therefore the ENDA exemption, applies to both non-denominational religious schools like Wheaton and church-affiliated schools. And as one court explained, even though the Christian corporation or organization is non-denominational, it nevertheless may subscribe to a particular religious view on which other Christians do not agree, and conversely, it may disagree with the religious views of other Christians. And to go on to the court, this is precisely the situation which Title VII exemptions were enacted, and the exemptions allow religious institutions to employ only persons whose beliefs are consistent with the views of that religious organization. And that is the purpose of this exemption. That is the purpose of this amendment. In addition to clarifying the scope of the ENDA religious exemption, my amendment also specifically states that the reference to marriage in ENDA refers to the definition of marriage as defined in federal law. Specifically, these terms in ENDA are given the meaning provided by federal law that is referred to in the Defense of Marriage Act, which defines marriage for federal purposes as the union of one man and one woman. This is the definition that applies to ENDA, and my amendment makes that definition absolutely clear. Madam Speaker, because of our amendment offers strong protection to religious organizations, including non-denominational, non-affiliated religious schools, I yield myself 30 additional seconds.
The gentleman is recognized.
Thank you. And because of our amendment clarifies the Defense of Marriage Act and operates to define the term marriage in this bill, I trust the amendment will receive a large bipartisan vote in its favor, and I would like now to yield to my co-sponsor of this legislation, Mr.